Now, in this lecture, I will be taking up something relating to public interest litigation. Now, when we take up public interest litigation, naturally, you are, except other than the law students, naturally are interested to know what exactly you mean by this. Now, there are certain issues which relates to the poorest of the poor people in the country. It may relate to their locality. It may relate to a public issue like waste disposal, or it may relate to some hazardous substances which are prevailing in the area. Or remember, it may be relating to the foams that come from the Arkavati river in Bangalore. Now, if it is allowed to continue, it will have the side effects to lots and lots of people everywhere. And how do you prevent it? And remember, the courts, in the ordinary courts, are not in a position to resolve the point because there will be delay in litigation. Cases are filed, but the cases, in order to come up for hearing, also takes time. Now, you might be knowing the judges of the High Court as well as the lower courts work overtime. They have, remember, disposed cases, so many cases on each and every day. But then these important cases, which may go out of hand and create some situation wherein it will cause irreparable damage to the health of the locality, or some other thing may come up. And that is why the court started interfering in special by way of petitions. Suppose, for example, an aggrieved party, suppose X, a person, he knows the kind of problem. It is not his problem alone. It is the property or the problem that is being situated in a locality. And since it is a problem which is situated in the locality, he is bringing in a representative action on behalf of everybody. This has to be done. If it is not done, remember, it will go out of hand. And the government will not be in a position to solve or resolve that issue at a later stage. Now, when I speak about this, there are, for example, take it this way, the pollution level in the state of Delhi had gone that far. Every one of you read it in the newspapers. The government has taken up precautionary measures. The precautionary measures which are taken by the government is not good enough. They are not able to realize any result. On situations of this type, remember, a few years ago, because of the vehicular pollution in the city of Delhi, because of the release of what we call as the dioxide elements and the carbon elements, carbon monoxide and other things, in the petrol which you use or a diesel which you use, people suffer a lot. The temperature of Delhi during summer would go up beyond 50 at times. Last year it has gone up to 50. And remember, you can imagine, if it goes up to 50, how one can live. And many people, I remember last year, because of the heat, year before last, because of the heat, they have left Delhi and came back. And simultaneously during winter, the temperature goes up to 0, especially during midnight. Now, these are all effects of climate change, and these are all man-made disasters. It is, man is privy to these things. Now, how it should be controlled, what can be done, that is the main question before the court of law. Now, the concept of public interest litigation, as the title simply says, it is, remember, the public take up a cause. When they take up a cause, it may not be their cause at all. It may not be their cause, it may relate to a public cause. And since it is a public cause, remember, they take it before the court of law and try to see that some kind of remedy is being given to them. That is why it is called as public interest litigation. It is the concerned people, affects concerned people in a locality, affects the society, or affects some community. In situations like this, one person or two persons or a group of persons or associations or NGOs They take up this matter and go before the court of law and try to argue the matter. Now, in this country, when I speak about public opinion, public interest litigation, remember, first and foremost, it was during the regime of Justice, Honorable Justice V.R. Krishna here, Judge of the Supreme Court of India, its origin began. And thereafterwards, along with the Krishna here, there was another judge by name, I forget his name, and he was also responsible. He was a main author in the famous Bhopal gas tragedy. Now, this person, Justice V.R. Krishna Iyer, in a particular case which is known as in Mumbai Kamgar Sabha versus Abu Dhabi, Abdul Dhabi. So, Mumbai Kamgar Sabha versus Abu Bhai. All India Reporter 1976. First and foremost, he coined the word public interest litigation. Thereafterwards, remember, it started. So it was initially, the very concept was initially sown by Justice V.R. Krishna Iyer in this case, Mumbai Kamgar Sabha, All India Reporter 1976. Thereafterwards, remember, in Fertilizer Corporation versus Union of India, AR 1986, the terminology of public interest litigation was used. So until 1986, the terminology of public interest litigation was not used anywhere. So it was in the Fertilizer Corporation Corporation versus Union of India. The concept of public interest litigation was used. Now thereafterwards, remember, in S.P. Gupta versus Union of India, that was a case which was decided in 1982. It came to limelight. It came to limelight for the simple reason matters relating to transparency and probity became one of the issues before the court of law. Now the point is how this petition is admitted. So when a matters pertaining to the public at large, if it is a serious matter, you can write a postcard to the court, the Supreme Court judge or the Chief Justice of India, and it will be entertained. That is the point that is being harped upon in the concerned case. Merely putting the facts in a postcard. Now, postcards are not seen at all. Now, you have to go to inland letter. So, if you write in an inland letter a particular issue, this is facing, and the matter should be resolved immediately, the Supreme Court may admit the petition and start hearing the cases. Now, this is one important aspect that is being spoken. In addition to this, an NGO who is championing the cause of the downtrodden, trying to protect the victims anywhere, everywhere, can also make an application before the court of law. Having gone before the court of law, if it is the Supreme Court of India, it can try to restore the rights under Article 32 of the Constitution of India. Or if it is the High Court, it is under Article 226 of the Constitution of India, they can request the High Court to restore their rights. So this is how it is being done. It may be an individual, or it may be a largely affected party composed of representatives or other interested persons. When I speak about interested persons, remember, exclusively interested in public interest, not personal or private interest. You may have private interest, so many. You may think that just in the presence of your house, there should not be any house. No, that is not possible because we collectively live in society. That is the fundamental issue. Now, when we speak about it, what type of court after hearing, what type of judgments it will give. When I speak about this, court will give or pass on orders, or it may give directives. So orders to see that any object which is a troublemaker will be made to be removed from that spot. That is one. Now, the other one is the direction that is being given, the direction given to the government, saying that it should not be allowed to done in the future. So that is where, remember, everything is restored to normalcy. Now, fundamentally, this concept of public interest litigation came in wherein, remember, the government of the day during its functioning started interfering with the public rights of the people or the rights of the individual citizens. And most of the petitions which came in the initial and formative periods happened to be under Article 21 of the Constitution of India or Article 19 of the Constitution of India. When we speak about Article 19 of the Constitution of India, you might be knowing it relates to right to life. Particular persons, due to exposure of noxious gases, is under threat and in peril. So if it is under threat and in peril, naturally, remember, they go before the court of law to protect the public from such effects. And the Supreme Court, after hearing the case, naturally gives a judgment or passes an order to remove, remember, and to clean up the entire area from the locality. That is why it is called as public interest litigation. Now, anyway, take it this way, you have seen on the TV, now the most of the waste that is being collected in Bangalore is dumped in a particular place. And when it is dumped in a particular place, the people living in the locality have objected. And they have filed a petition saying that the entire area is full of noxious fumes. And these noxious fumes are deadly hazardous. And they are hazardous in such a way, the very consumption and exposure of it will result in cancer. Remember, in 1930s, in America, researches used to take place. In the researches that used to take place in the universities, they would go to the extent of pointing out persons working in the cement industry would naturally get cancer. But then, remember, the scientists were not able to prove beyond doubt that a person working in the cement-related industry is going to get cancer. But then when we come to the year 1980, the scientists in the state of the United States went to the extent of proving that an exposure of an employee in the cement working industry in the state of the United States for continuously for 1 or 2 years naturally would result in getting cancer from the exposure. Now that is why they said hazardous industries means even the cement industries are hazardous. A person continuously working there for 8 hours or more every day as a regular employee is going to get or to suffer from cancer. No, by 1990s it became clear most of the asbestos related industries generate cancer and victims are the people mainly who work in the factories. Now suppose, for example, now certain areas wherein these industries function and they cause hazardous effects on health. But then they don't even take precautionary measures which are put by the government of India. So if this case, if a petition is filed before the court of law, naturally it will be entertained by the court of law and remedy or justice will be given to the parties. Now, I just intend to speak to you a beautiful case which we came up before the Gujarat High Court that went before the Supreme Court. Abhilash Textiles versus Corporation. And the name of the case happened to be, it is a Gujarat related case. Now, in this case, what has happened was there was a cloth manufacturing factory. And this cloth manufacturing factory was manufacturing clothes. And in Gujarat, there were as many as 25,000 plus or more employees were employed in this. When I speak about clothes, remember, clothes naturally had to be given color. And when the color is being given, remember, some of the material that is being used in this are chlorine and some oxides. And these oxides and the colors are, remember, used for the clothes in the factory are deadly. See, here is a factory, and just in the vicinity of the factory, in a kilometer of 5 or 6 miles, 25,000 employees are working. And the employer for 25 years used to release the chemical waste in front of the factory. See, just used to release the color waste which is used for clothes in front of the factory, and that would affect every employee of the factory. And naturally, the employees would suffer from diseases. Now, this is Abhilash Textiles versus Corporation, Gujarat Corporation. Now, the matter was taken up before the court of law. When the matter was taken before the court of law, we remember the concerned employer was telling, we have been doing this for 25 years and nobody said anything. And it has become a right for us. And remember, then the other thing is we have a freedom to profession. Article 19(1) under ABCD, one of the D, I think. Freedom to hold a profession. We are enjoying our profession and carrying on our activities, and you cannot come and interfere with our rights. We have been releasing this gaseous, noxious fumes, deadly fumes, hazardous waste, and hazardous containing of hazardous chemicals for 25 years. But then the court said, if you have been releasing for 25 years, the liability will still be more. It cannot be done. So for the first time, either you close down the factory, and if you don't want to close down, remember, see that the release of this waste, chemical waste, is diverted to some other area, wherein it is not going to cause any other damage to anyone. This is what the court of law in this case pointed out. That is why it is a speedy remedy which is given to the victims or parties. Now, when I speak about the what we call as the public interest litigation, especially in India, it is of three types. Now, initially, it started protecting the fundamental rights, basic rights, which are enshrined under Article 21 of the Constitution. And thereafter, it shifted to environmental protection. Remember, environmental protection is a basic right today, a fundamental right. You have to live in a clean environment. You have to get, remember, safe drinking water. No, a drinking water which is free of pollution. In the state of Bihar versus Satyendra Nath Pandey, the Supreme Court for the first time pointed out everyone has the right to life, and the right to life to live in an atmosphere which is pollution free. Sachidananda Pandey versus State of West Bengal. This was repeated in Nelikai Achyutan versus State of Kerala at a later date. Now, I am just telling you, these are basically related to the rights in the initial stages, protection of the constitutional rights. Remember, the concept of public interest litigation naturally gets a very good response from the directive principle of state policy. Under the directive principle of state policy enshrined in the Constitution, which is called as Part 4, the object of the society is socialist pattern. Everyone, each one of them should be in a position to get justice. And everyone is entitled to get protection. Everyone is entitled to get healthy food and nutrition diet related to medicines. Now, this is the object that is being spoken under the law. So, in circumstances as this, for the true enforcement of the objectives of the Constitution and fundamental rights, cases is to go before the court of law under PIL. So, the first part of the story is, remember, for the enforcement of the constitutional rights, enforcement maybe of the rights of women, enforcement of the rights of children who are distraught. This is very much essential, was the fundamental question. I can just give you 2 or 3 instances of this type. Now, one important case that came up under the public interest litigation happened to be the famous Asiad case. Now, today we call it at the Jawaharlal Nehru Stadium in Delhi. When it was constructed in the 1982, it was the huge stadium. And it was supposed to be the best stadium, and lots and lots of workers, remember, manually would come to Delhi, stay there and work. What has happened was the construction of the stadium was given to contractors. The contractors who undertook to execute the contract would employ laborers. And these laborers, remember, as you know, in the COVID era, happened to be migrant laborers from Bihar and Orissa and from other places, Haryana also. Remember, since they come from Orissa, Bihar, and even West Bengal and from other places, they were exploited to the hilt. Maximum exploitation has started taking place. Remember, they were made to stay in just like open air. They were not provided with toilet facilities. They were not even given, remember, proper drinking water in a few cases. And exploitation went on and on and on. And they were, remember, paid only 10 rupees per day as wages at that time. And this is too small. We get nothing out of this amount. So you don't have, remember, proper unadulterated food to eat, pure water to drink, live in a place wherein you have sanitary conditions, atmosphere, toilets and other things were empty. You will sit in the open, both men and women. They come to work and you extract the work for 15, 16, 17 hours a day. And you give them just a penny of money and execute the work. Now, in circumstances such as this, remember, certain social activists and NGOs, they realized the pulse of the problem. They said this should be brought to the knowledge of the Supreme Court and everything should be regulated under the existing labor law. Now, when I speak about the labor law speaks about minimum wages. You have the Minimum Wages Act. Minimum wages were not paid at all. And if you ask more wages, that fellow will be kicked out from the area. Next day, he doesn't even have a job. Much less he has money to go to his native place. When it was brought to the Supreme Court of India heard the argument. Having heard the argument, remember, gave a judgment saying that all the labor laws are to be enforced. And these employees who are working in what we call as the building up of the Asiad, Jawaharlal Nehru Stadium, must be properly paid and they should be looked after. Food, it should be unadulterated food. Then housing means living space should be provided, toilet facilities should be provided, and they should be treated like human beings. That is where, remember, overnight in the 1980s, it became famous. Now, this concept was used by V.R. Krishna here. He was the one who is saying that there is a constitutional duty to protect the rights of every person in this country. And those who have money, they can go before the court of law and argue the case. But then those who don't have anything, what will they will do? Where they will go? So in such situations, a public cost has to be taken by what we call as organization or by some persons who are championing their cause and go to the court of law and get it done. Now, this is one such case which came before the court of law. Now, thereafterwards, remember, in Tamil Nadu, there was a case which came up before the court of law. Remember, there are people who prepare agarbattis, factories of agarbatti factory. In the agarbatti factory, what used to happen is, remember, those fellows who would work were not even given protective clothes. And without using the protective clothes, these agarbattis were manufactured. And most of them, remember, it is called as ranjak in Kannada. And they have burnt their hands, burnt their skin, and still were made to work. And most of the fellows were not in a position to, remember, take food into their mouth. And not even able to hold spoons to put it into the mouth. Now, in circumstances, the matter was challenged, and they said somebody said their pathetic condition in the entire area. And suppose, for example, as I just mentioned to you, people who are using workers who are always made to work with the colors. It is deadly. It is poisonous. And there also, remember, the fingers will be burnt. Now, for this, there came a beautiful judgment saying that first and foremost, for all persons working in the factory, there should be gloves, protective clothes should be provided. And along with that, anybody who is infected with this shall be provided with the treatment. And even though they are laborers, they are first and foremost human beings. This is one of the constitutional goals which is being protected and given under Article or also the Constitution, especially the Directive Principle of State Policy. Now, for example, take it this way. I just mentioned to you hazardous waste disposal. Hazardous waste disposal takes place, remember, every day on day-to-day basis, and you dump in several areas wherein people live in. And neither the consent of the municipality there, consent of the panchayat there, or the consent of the corporation you take, and the corporation people go and dump and come back. Now, after 10 years, remember, its ultra hazardous effect will be heard. What do you do at that time? This is the thing. And in Delhi, what has happened was, because of the pollution that is being created by vehicles, and because of the NGOs filed before a petition before the court of law, because of the what we call as the respiratory disorders which has taken place among school children and others, when the issue was brought before the court of law for the first time in the history, it was a landmark judgment. They said CNGs should be used. All the vehicles from now on should be made of CNG. That is why we have CNG vehicles in Delhi. You don't find in other places. That is done with a view to prevent the spread of pollution so that everyone is safe and safeguarded. Now, this is how it is started. So, in the initial stage, it is to protect what we call as the basic fundamental rights of the human being. When I speak about protect the basic fundamental rights of the human being, especially 21 and 14 and 19 of the Constitution, then we go to the second stage. When we go to the second stage, it is relating to what we call as the protection of the environment-related issues. Now, one such issue I just intend to bring home. There are several others. I shall tell you one by one so that you understand the point better. Now, there is a case which came up with Godavarman in the state of Orissa. Find out, type out, you will get Godavarman's case. What is it like? Now, mining activities used to take place in such a hectic way, and it led to desertification. See now what is happening in or Ballari. Desertification of forests, everything is taking place, and the effects will be heard, and that is why the climatic conditions in Ballari is totally different from in other districts of the Karnataka state. Now, in Godavarman's case, what has happened was mining operations which were carrying has resulted in so many environmental problems, including pollution. The Supreme Court of India heard the matter. Having heard the matter, it went and pointed out. Now, all national parks or sanctuaries, wherever it is situated, wherein within a kilometer's range, within 1 kilometer's range, you cannot have mining operations. So today it is the law. When I speak of the law, within 1 kilometer range of a national park or a national sanctuary, one cannot indulge in mining activity because that is not environment friendly. It is hazardous. It is deadly. It is going to kill so many lives. This was a remarkable judgment which was given by the Supreme Court of India. Now, that is to protect the environment. Suppose, for example, within 1 kilometer, if you start mining operations night time, you know that recently what is happening in Shumaga area. How many people are dead? That is why they said in near wherever national parks, wherever sanctuaries are situated, in that area, in a radius of 1 kilometer, you cannot have any kind of mining. Now, the other one that is being spoken happened to be Volga Telly's case happened to be another important case that came up. Right to life means right to livelihood as well. See, because a beautiful decision which was given by the Supreme Court of India. Right to life means and includes right to livelihood. You have the right to live, and that is also part of the decision which was delivered by the apex court. Now, when we go further, there was another case which came in, which is known as Vellore Citizens Forum versus Union of India. Now, in Vellore Citizens Forum versus Union of India, what the court pointed out was, another public interest litigation pointed out was, remember, first and foremost, there should be a principle known as precautionary principle. And this precautionary principle must be applied always. Now today, you might be knowing precautionary principle. When I speak about it, as they call it as EIA, reformed version. EIA means environmental impact assessment. Before a project is carried out, you should undertake a environment impact assessment. Whether this project is good, whether this project is going to cause harm, if it is going to cause harm, to whom it is going to cause harm, what is the nature of the harm, what is the nature of destruction, and what is the conservation strategy to protect this. So that is why it is called as EIA. For the first time, it said, first and foremost, for every project, you have to think of precautionary principle. Unless and until you take precaution, first one is anticipate the destruction, then attack the destruction, then provide a solution to the problem. Now that is very much essential. Otherwise, you cannot carry on these types of activities, was the judgment of the Supreme Court of India. Now, the other important case that came up again by way of a public interest litigation happened to be the Kanpur tanneries. Especially Kanpur is known for leather products. And in these leather products, remember when the leather, they wash the leather with chemicals. And when once it is being washed, remember the water will go just like a small river and will join the great Ganga. Mother Ganga has the capacity to absorb everything. And that has resulted, remember, in a few deaths and the pollution of the river. Two objectives. One is employees who are working in the factory, when they wash this leather with the chemicals, they inhale the smell and they are affected by it. In situations like this, what is the remedy? Now, the other thing is the entire water goes to what we call as the Mother Ganga, reaches there. Now, you might be knowing in the way to from here, Bangalore to Hubli, when you go in Harihar we had polyfibers. Harihar polyfibers used to release the entire waste, chemical waste generated by them because of the suiting cloths and other cloths which is being manufactured by it. Ultimately stopped. It had to be stopped because the people in the area went on strike. They went to the extent of pointing out these chemicals which are used in the factory are released to the entire Tunga river. And when once it is reduced to the river Tunga, naturally the people who live in the lower side naturally take the water and they are infected with the diseases. That is one, that is deadly diseases because they are huge poisons. Now the other important thing is in this area they complained and they asked for the closure of the factory. And there, remember, the factory was closed for some time. But in spite of it, remember, some activities are going on. And these activities for a period of time will have to be controlled by the government of the day. Now, most of these issues are, remember, relating to the workers who work in the factory, who are generally on day-to-day basis exposed to these kind of chemicals. Their objective is to protect this. Similarly, in the Kanpur tannery case, leather, washing of leather from maybe shoes or some other things, bags or other thing, there they would get infected with the diseases. And the Supreme Court for the first time ordered the closure of the factory, and then it was opened with almost all the available technology inside the factory. This is a fundamental case which I just wanted to speak to you. Now, you might be knowing there are instances wherein the Ganga cleaning operations were done. When I speak of the Ganga clearing operations, it was done not now, during Rajiv Gandhi's prime ministership itself. He brought money from Netherlands and started doing it. But then the more you try to do it, the more pollution is taking place there, because people start releasing the hazardous liquids there, which are poisonous and deadly. And if you go to Kashi and other places, even open dead bodies are being thrown on the river. What is going to happen? Now it is okay. Now after a few years, what is going to happen if these things are allowed to be continued? That is why pollution is everywhere be dangerous. Now the important aspect that I just wanted to speak about to you is uh, SP Muddappa versus medical trust. Now what has happened was, in certain areas, uh, the government has allocated lands for the purpose of building gardens. So SP Muddappa's case, SP Muddappa is not an ordinary man, he was the chief secretary to the Karnataka government. So the government corporation has allocated certain area to build a beautiful garden, so that the people who are above 60 could go there and breathe, inhale pure air. Now what has happened was, there was a medical college which was supposed to come up, medical trust, Bangalore Medical Trust, which wanted to take away the property which was allocated for building gardens or establishing gardens. Now immediately the matter was challenged before the court. And the court went to the extent of pointing out what is important is, remember, the people should live in a safe, healthy environment, an environment which is free of pollution. And the land which is allocated for generating a pure environmental status cannot be given for establishing a medical college. This cannot be done. The objective will get defeated. Now, another issue came up before the court of law, and this issue happened to be an issue relating to a case wherein Hyderabad versus Municipal Corporation. Now, in Hyderabad Municipal Corporation, Damodar versus Hyderabad Municipal Corporation. That is the name of the case. So it's decided by the Supreme Court again. Now, what has happened was, certain property under the corporation area was allocated for having certain infrastructure, beautiful gardens. And these gardens should help the children as well as the old parents to inhale pure air in certain areas where you have thick population. Population is huge, but in that area, they should be in a position to breathe good air. Now, the Income Tax Department as well as the Life Insurance Corporation of India wanted to take away this property. See, corporation allocates certain areas for having gardens, beautiful gardens. This area was, remember, was knocked off or taken away from the corporation authorities by clout, by influence, by pressure, by the Income Tax Department of Hyderabad as well as the LIC, Life Insurance Corporation of India. Now they wanted to take this land for building, remember, houses for their employees. They wanted to make it as an IT colony as well as LIC colony, residential purpose. No, Damodar, remember, did not leave at that. He goes to the court of law. He points out this is done for this purpose. And the population of Hyderabad has already gone so much. And pollution is everywhere. And environment-friendly methods are not adopted. In such situations, this should be cancelled and there should be restoration, and it should allow and facilitate the setting up of what we call as gardens. Now, the Supreme Court, having heard the matter, went to the extent of pointing out, remember, health is a concern of everyone. And the government of the day or the municipal corporation of the day, whichever party is in power, should facilitate these things. They are not supposed to destroy. With the result, they went to the extent of pointing out the corporation, if it has allocated the land, the act which was done is void and it should be for a greener purpose. That is the message which was given by the government. So there came another beautiful case again, public interest litigation. State of Himachal Pradesh versus Ganesh Woodworks. Now, in the state of Himachal Pradesh versus Ganesh Woodworks, an interesting issue was raised. And this issue, another interesting issue happened to be in the event of a dispute between the parties. Now, whether the state law is important or the union law, the law passed by the government of India, which one should be respected and adhered to? Now, in this case, what has happened was the Himachal Pradesh government had passed such legislations. And thereafter, the central government also on this subject came forward with the legislation. So there was a conflict which one shall be referred to and adhered to. Now, the Supreme Court of India, while delivering the judgment, pointed out 3 to 4 essential principles. First and foremost, remember the law that is being enacted by the government of India will prevail. So that is, supremacy is given to the law which is being passed by the Union Government of India. Now, suppose, for example, a state law which is being passed on the same subject, if it is not approved by the central government, the central legislation will prevail. Any state law, suppose where an issue comes up wherein the matter is in the concurrent list, both the state as well as the center are empowered to pass a legislation. When the matter is in the concurrent list, the state is empowered to pass a legislation, but the legislation that is being passed by the state legislation has to be approved by the center. And if it is approved by the center, remember, the law that is being passed by the state will prevail over the central legislation. So this is how Supreme Court pointed out. Now the second important thing is what we call as the authorities who implement the legislation are supposed to implement the laws in accordance with the legislations which are passed for that purpose. Remember, there cannot be, remember, you can't just say, I am implementing the law like this, like that. No, that cannot be. It should be in accordance with the spirit and letter of the law that is being passed by the government of the day. That is what is indicated by the Supreme Court of India. Then it said, while implementing the law or while taking steps, it is the duty of the concerned government to take up important aspects. The first one is what we call as the concept of sustainable development. When the concerned state makes use of the resources, it should also think to promote and protect and increase the resources for the future. That is why you are not supposed to exhaust completely the resources. But the resources which are used, remember, you should be minimal use of resources. That is one. The second one is, it spoke about the intergenerational equity. See, in public interest litigation, intergenerational equity, what does it mean? When you make use of resources, you should also know that the generations which come after us also should be in a position to make use of resources. When I say about this, the generation which comes after us, they also should be in a position to make use of resources and you should keep them as well. That is why when we speak about the concept of just the sustainable concept is a continuing concept. Sustainable development is a continuing concept for the simple reason, when you are the head of a family, you are supposed to use the resources in a limited way. And so that the resources are passed on to the next generation. When your children come into the picture, again the concept of sustainable development comes into the picture, because they are supposed to use the resources in such a way wherein damage is caused, not cost is to the environment. And it should use in a limited way. Their children, again same, they cannot destroy exclusively and make use of it for themselves. That is where intergenerational equity principle came in. And it was established, it was endorsed, and it was respected by the court of law in the concerned case. Now, there was another beautiful case which came up, B.L. Vadhera versus Union of India. Now, in B.L. Vadhera versus Union of India, when this case came up, now you may be interested to know for what purpose it came. Now, first and foremost, the government will make the legislation, and then it will ask the pollution control boards or some other agencies to implement the legislation, those who are concerned with. Now, these agencies who are supposed to be concerned with the implementing the law would go to the extent of pointing out we cannot implement these legislations for two reasons. The first thing is we cannot implement legislation because we don't have money. Where is the money? Unless and until money is given, we cannot implement, we cannot think of implementing the legislation. The second one, they will say, remember, we don't have proper personnel. We have not employed anybody. Since we have not employed anybody, we can, without employment of this personnel, we cannot implement. No. Supreme Court, having heard the case, pointed out such excuses cannot be given before the court of law. You cannot plead before the Supreme Court of India in a litigation saying that we don't have money, we don't have proper employees. And in all situations, remember, you have to make application to the government. Having made application to the government to see that employees are appointed and certain resources are taken, whatever is required, make proposal in the budget and take the money and make use of it and protect the environment. That is what it said. See, when I speak of all these developments, what is important is today the concept of right to life has gone that far. It's huge, huge. A jurisprudence is being developed. Now you may be interested to know what this jurisprudence is all about. When I speak about the jurisprudence, the first one is the right to life means it includes the right to what we call as medicine. That is why the present Prime Minister has established what were the cheaper medicines which are available in every city. And the price of these medicines are, remember, subsidized. It is very less compared to the same medicines which are available in the market. So right to medicine is a basic right, which is part of the right to life. Then the right to food. You just think of the Food Security Act of 2013, right to food. Now today, a particular person gets, remember, at least 6 kilos of rice. Earlier it was more. Now that much the government is assured, saying that we will give you this much so that nobody should starve. Now that is where, remember, for the welfare of the common good, for the welfare of everyone in the society, for protecting the least protected, for taking care of what we call as the poorest of the poor, the public interest litigation has come in and it has been helping them and it has assisted them and it has contributed to the growth of equality in a socialistic pattern society of ours. That is what the message is all about. So in B.L. Vadhera versus Union of India, I just told you, in a case before the court, you cannot plead, we don't have employees, we don't have money. They will just tell, remember, you have to do it. Now, for purpose of implementing environmental law, there are other cases that came in as well. And in other cases, they pointed out a particular factory which generates hazardous substances and hazardous waste. If it is not listening to the government or the enforcers of law, first you stop electricity and then you stop water. So stopping of water and electricity to a factory naturally will get down to a standstill and the factory will be closed. Suppose, for example, a particular factory is generating hazardous substances. Having generated hazardous substances, remember, it has caused so much of problem. In situations of this type, what is important is notice will be given to stop this, and if they don't listen to this, first one is stop electricity, then you stop water. And don't give them So that is what is important under the present day law, to see that environmental law is enforced in this country. Now, the other important area which I just wanted to bring home happened to be uh, wait. The other important areas that come up before the Supreme Court of India on this matter relating to what we call as hazardous substances. Hazardous substances like hazardous waste. For example, most of these laws, especially in the area of hazardous waste as well as hazardous substances or hazardous waste management rules of 2016, have come in after the decisions of the Court of Law. Now, one important point which I just wanted to bring in notice. Now, when we speak about this, especially matters pertaining to environmental law, it is being enforced by a proper agency. And when it is enforced by a proper agency, there should be what we call as probity in public life. And when I speak about probity, most of the questions which are decided on merit. Now, I can just give you the statistics of the Supreme Court of India, especially in delivering environmental matters. In the public investigation, the first stage is protection of basic rights. The second one is the protection of the environment and protection of the rivers, protection of the lakes, etc., etc. See, for example, the government of Karnataka the other day had thought of improving the existing lakes in Karnataka. Especially in Bangalore, you have so many lakes, 87 of them. They are to be protected and they are to be remembered, cleaned on an annual basis at least, if not everywhere. The silt which is being found by the side of the dams are to be removed every year for purpose of storage of water. Now, all these issues naturally first discussed under public interest litigation in a state, and then it became a litigation. Now, the point at issue which I wanted to ask you is, now whether the court is supposed to admit every petition. What is your answer? Are you listening? Whether the court is empowered to listen every petition that is being submitted by an NGO or by an affected party or by a group of people. The answer is no. The court need not listen to everything submitted by everybody. Now, suppose, for example, if it listens to everything and thereafter starts hearing the particular case, the Supreme Court will be flooded with public interest litigation only. That is not possible. Now, public interest litigation is a type of litigation wherein the basic rights of the poorest to the poor are affected. And these poor suffer in indignity. Because the rich people can go to the court of law and get justice. The poorest cannot pay the court fee, much less they can go to the premises. In circumstances such as this, either in an NGO or some other takes up the issue and argues before the court of law. Now, the point is, suppose, for example, an issue is being taken up and an issue, when it is argued on merits, it comes to know that it is a frivolous issue. What is this frivolous issue? It is all, there is no issue at all. It is a bogus issue. It is only to damage the country. At that time, remember, if it is an ordinary case, the court will warn and impose a fine, normal fine, to the concerned party who have gone before the court of law to file a case on public interest litigation. Suppose, for example, the concerned party has gone to the court of law is a frivolous and a serious issue. Deliberately, it tried to rake up certain issues which is not there. In such cases, remember, it can dismiss the petition, and having dismissed the petition, it can go to the extent of finding out that this petition cannot be accepted, and the concerned person will be fined also. They may impose heavy fine. There are instances in the recent past that the court has imposed heavy fines on simply disturbing the Supreme Court of India in its work in the name of or under the name of public interest litigation. That is not allowed to be done. This is a fundamental point which you remember. So I just said you the right to life means and includes right to medicine, then right to food, which I told you, then right to live in a pollution-free environment, right to education. See, fundamental right under Article 21. Now, these are all added to what we call as Article 20 of the Constitution these days. Now, it are all added for the simple reason, for example, take it this way, the one who made the law, one who made the Constitution, or Constitution makers, were not aware of these rights because most of the new people in the then time, in 1945 to 1950, they were part of a joint family. Today, joint family is disappearing and what we call as small families are coming up. In such situations, remember, they have to include many other rights as well. For example, take it this way, I was just speaking to somebody the other day in another forum of the law on privacy. Where was the law on privacy in the 1950s? Whether the constitutional makers could think of the concept of privacy in those days? When they were living in a joint family, remember, could they think of the law of privacy? Now today, the law of privacy has gone that far, wherein, remember, it is protected and respected in everything. And the law of privacy, even in communications, everywhere, it is operating. And the Supreme Court of India also recognized this, the right to privacy in its judgment recently. Now that is why when we speak about the law of life, it also changing and many other aspects are brought into it. And under public interest litigation, this is being improved upon as well. 1 minute, 1 minute. I just want to speak to you the third phase of the public interest litigation. So the third phase of public interest litigation is on a new item. So first one relates to basic rights, fundamental rights, right to life, right to live with dignity. That is why it went to the extent of protecting the unprotected. Now, the second is protection of the environment. There are many cases, hundreds of them. I have at least told you about 10 to 15 cases here just now. Now, the other one, the most important part happened to be a case which is public probity and transparency. In the recent past, there are several cases that have gone before the court of law. And these cases which have gone before the court of law are on probity in public life. See, what is happening is, over a period of time, I'm not bringing politics, the values in life, in public life, have deteriorated. And the people who work in public and who are in public life, or the representatives, are not following the norms which ought to have been followed by them. That is where, remember, this has to be enforced for a society. We should live in, remember, good faith and truth. Now, there are several cases which came before the Supreme Court of India, and this relates to transparency as well. Now, when I speak about the transparency, for example, transparency in the contract law. Now, there is no transparency. See, for example, I can just tell you, you also know this. Now, a huge contract is given by a government anywhere, a hypothetical example, only to a particular person. And with the result, remember, there is some kind of corruption that is being done by the contractor and he gives money to the government. And then some of the litigation which went, it said it cannot be done like that. Then then another set of came, there will be 4 or 5 of people who are the bidders. And what happens is only these bidders, remember, ultimately give the final bidding. And in one contract, one of them will be taking, and in another, the second, in the third contract, third, the fourth. Now, what happens is the entire government money will be rotated through these 4 contractors, and they would go to the extent of saying that the government is hand in glove with these contractors because they are getting the money is reverted back. Now, there are certain instances wherein the Supreme Court in the public interest litigation laid down the norms as well. And it went to the extent of pointing out these norms are to be followed stricto sensu. And it should be followed in stricto sensu for the simple reason that if this is not done, remember, society is not going to function effectively. Now, a case came up before the Supreme Court of India, SP Gupta versus Union of India. And in this case, remember, for the first time, the writers go to the extent of pointing out public interest litigation firmly rooted in this country, especially in the lawmaking process. Now, the other area of public interest litigation that came in happened to be an area wherein the authorities, the executive authorities, trying to, remember, mull the constitutional provisions. They don't even follow the constitutional provisions and afterwards take certain decisions which is contrary and which is ultra-virus, outside their capacity. Now, you might be knowing executives, when I speak about, remember, executive branch, the deputy commissioners, they are the ones who implement the law. Or assistant commissioners, or tahsildars, or revenue officials. So, starting from the revenue officials, or what we call as village accountants, all of them are executives. And when they implement the law, remember, they are not following the norms and they flout the norms and fluctuate the norms and do whatever they want. And remember, where is purity in public life at this juncture? The government with good intention enacts the law. But when it is enforced by the executive, there should be certain things which are to be respected. And for purpose of enforcing probity, honesty, truth, and what we call as transparency, the public interest litigation has come in and it has decided several cases on these subjects as well. Now, the other important thing is there are instances wherein the Supreme Court has dismissed the petition, saying that there is no crux in the matter, there is no truth in the matter. And there are instances where the Supreme Court said what we call it, the petition itself is frivolous and imposed fine. And fine may be exemplary fine or nominal. And there are instances wherein it dismissed the petition and imposed heavy penalty. Now, don't be under the impression that for everything you can go to the Supreme Court of India, especially under PIL. The Supreme Court is always guarded. And it go to the extent of pointing out only such cases wherein it has hurt the poorest of the poor. Their rights are denounced. Public interest litigation will lie.